53, it's better. It's completely reproduced for us. Yes. Page 54 at the bottom. It happens sometimes, though not very often, that a magistrate hearing a case against certain. I was actually reading Shashikant's judgment, and knew that is 2002, volume 5, 7. And my submission was that
You are almost concluded reading that.
Yes,
You are submitting that the observations therein are not correct in law.
But my
with regard to mandatory and direct.
My submission on that is that so far as it holds the 3191 part to be directory, that in my respectful submission is not correct. 3191 is the material provision,
and the rest of them are procedural.
Yes, the rest of the 3 are procedures as to how it will proceed. Is my first submission regarding Shashikant. My second submission regarding Shashikant is, in any case, Shashikant is a case where the 319 order was passed at the correct time. And that is how the reference order has also distinguished Shashikant. But anyway, that's not binding, or that's neither here nor there. So therefore, according to me, Shashikant was a case where the order had been passed at the correct time. And therefore, Shashikant is entirely different on facts. Now, Shashikant has been relied 2 times thereafter. Both judgments are in the learned solicitor's compilation. I'll refer to them at a later stage just now. There is no further discussion on what Shashikant holds. Shashikant's principle has been picked up and applied twice again. First, it has been applied in 2002, volume 5, SCC 738. If your lordship feels your lordship can just, it has been applied in 2007, volume 7, SCC 378. I'll refer to these 2 judgments a little later, my lord. Let me first. So my second submission on Shashikant is that it is entirely different on facts. There the order was passed within time. Then, my lord, we come back to interpreting 3191 itself. Now, on that, my lord, I have just a small compilation. There is the Law Commission's report on the basis of which the provision itself was introduced. Your lordship may kindly have that report of the Law Commission. Where is the page? Give me the page. That is at page. Well, this is only the Law Commission's report and 3-4 judgments where the same principle that I'm saying has been. Just kindly have the last page 53 onwards of what the Law Commission says, my lord. At 54. 53 at 54. This is the 41st Law Commission report, on which basis section 351, which was earlier there, was amended and renumbered in the new code as 319. Now, the reason why I'm reading it is, this also says you can join him in an ongoing trial, not after the trial is over. The whole purpose of amending this section and introducing it as per the Law Commission was to enable the person to join in an ongoing trial. And therefore, Hardeep Singh is absolutely right in its conclusions, is my respectful submission. And my lord, I would rather say the principle in Shashikant, it does not even arise for your lordship's consideration, because Shashikant is a case where 3191 was passed at the correct time. Now, kindly have this bottom of page 54, my lord.
But earlier, 319 was amended, or it should unamended? Has it been amended?
Yes, 351 was altered slightly. And
that is prior to the 73 Act. CRP
no, under the 89 code, old code.
89.
Yeah.
So it was an amendment. Actually.
No. It is reintroduced in its present form after making the modifications which the Law Commission has suggested. Once your lordship reads this, the lord.
What are the pre-amended positions?
My lord, pre-amended.
55 is pre-amended.
Yes, there were only persons attending trial who could be joined.
Can we have that?
Yes, I'll just get it. Only a person who was actually attending. Once I read this 24.8, it will become clear. Lord. This explains the previous position and the new position. Let me read page 54 at the bottom. Okay, okay. So, your lordship may have Hardeep Singh at 113. It quotes the earlier provisions. Hardeep Singh quotes it in at page 113. Yes. If your lordship will have the judgment in Hardeep Singh, that is
In the compilation, what is the page?
in this compilation.
Page 22.
It is at page 1 of the compilation given by the
Page 22.
Internal page 22. of the
Yes.
compilation.
yes internal page 22.
What para, Patwale? Any idea?
Para 10.
Oh.
Para 10.
Yes.
Para 10. In order to answer the aforesaid questions posed, it will be appropriate to refer to section 351 of the Criminal Procedure Code, where an analogous provision existed, empowered the court to summon any person other than the accused if he is found to be connected with the commission of the offense. However, when the new CRPC was being drafted, regard was had to the 41st report of the Law Commission, wherein paras 24.80 and 24.81 recommendations were made to make this provision more comprehensive. The said recommendations read: the 351 limited to this is the same recommendation actually.
This is the same recommendation.
Yes, this is what I
Except from that, those.
yes. I can read it from there, but it was limited to offenders in court. Section 351 limited to offenders in court. But then let me read it from page 53 because the complete thing is there. 24.80 is reproduced. Let me read it from page 50. It's completely reproduced there. Yes, page 54 at the bottom. It happens sometimes, though not very often, that a magistrate hearing a case against certain finds from the evidence that some person other than the accused before him is also connected in that very offense or in a connected offense. It is only proper that the magistrate should have the power to call and join him in the proceedings. Section 351 provides for such a situation, but only if that person happens to be attending the court. He can then be detained and proceeded against. There is no express provision in section 351 for summoning such a person if he is not present in court. Such a provision would make section 351 fairly comprehensive, and we think it proper to expressly provide for that situation. Section 351 assumes that the magistrate proceeding under it has the power of taking cognizance of the new case. It does not, however, say in what manner cognizance is taken by the magistrate. The mode of taking cognizance are mentioned in section 190 and are apparently exhaustive. The question is whether against the newly added accused, cognizance will be supposed to have taken on the magistrate's own information under section 191C or only in the manner in which cognizance was first taken of the offense against the other accused. In concrete terms, if the original case was instituted on a police report, that is under 191B, will cognizance against the new accused be supposed to have been taken in the same manner as under section 191C? The question is important because the methods of inquiry and trial in the two cases differ. About the true position under the existing law, there has been difference of opinion, and we think it should be made clear. It seems to us that the main purpose of this particular provision is that the whole case against all known suspects should proceed with expeditiously, and convenience requires that cognizance against the newly added accused should be taken in the same manner as against the other accused. We therefore propose to recast section 351, making it comprehensive and providing that there will be no difference in the mode of taking cognizance if the new person is added as an accused during proceedings. Please note, this is of course necessary as already is provided that in such a situation, evidence must be reheard in the presence of the newly added accused. The offense for which the newly added accused can be tried is not indicated in precise terms in the section. Obviously, the offense should be connected with the one for which the original accused is under trial, also present tense. To bring that out, a small verbal amendment is recommended. Section 351 should therefore be amended as follows, and then that 319 as it stands today is reproduced. And at page 57, ultimately, it is accepted by the Rajya Sabha. Page 57 at the top, second column, top rank, it's clause 198 to 319 were added to the bill. So 319 is added by the Rajya Sabha. So, my lord, three parts I've already highlighted. At the top of the page, in the fourth line, it is only proper that magistrate should have the power to call and join him in the proceedings. So the proceedings have to be live. Second, I have already said in the lower half of para 25.81, during the proceedings. And the third is when the proceeding is under trial. So therefore, my lord, that is how ultimately my lord, 319 as it stands, for the proceedings to be live, it is very important. And therefore, what Hardeep Singh holds is absolutely correct. And Shashikant doesn't take that away, because Shashikant is a judgment where 319 was passed in time. And your lordship was faced with a situation where, because of the person added going to court and getting an injunction, etc., the proceedings could not continue. And therefore, your lordships found via media that he should not be allowed to take advantage of his own wrong. Now, my lord, I have given in this compilation that I have just given to your lordships some judgments, my lord, where Hardeep Singh has been followed by your lordships, and some judgments of high courts only as a persuasive value, my lord, where your lordships will see where various high courts have taken the same view before and after. And if your lordship will have this compilation at page 1 is the judgment, my lord, of 2017 7 SCC 706. And I must say there is no added discussion. It's just Hardeep Singh has been followed. I mean, so far as the two judgments of your lordships are concerned, Hardeep Singh has been followed. And the first judge, your lordship may kindly have at page 8, para 10 of Brijinder Singh. Para 10 at page 8 says, it also goes without saying that section 319, which is an enabling provision, empowering the court to take appropriate steps for proceeding against any person not being accused, can be exercised at any time after the charge sheet is filed and before the pronouncement of judgment, except during the stage of 207, 208, etc. Then para 11, my lord, is the further what Hardeep Singh says, what is the evidence? And para 12, what is the degree of satisfaction required? Again, I am not actually going into all that, because then your lordships have said that your lordship
beyond the reference.
Yes, your lordship will be sending it back. Though the third question referred is, I'll read that. That I submit is completely covered by the rest of Hardeep Singh. I'll come to the third question, my lord. So this is one judgment where Hardeep Singh is followed. Then, my lord, another judgment where Hardeep Singh is followed is at page 35 in 2021 itself. Yes. At page 35, if your lordship will see, that is not reported in SCC. So I have the SCC online citation for your lordships at page 35. Now, again, the page 40, para 33, when the discussion starts, Hardeep Singh is considered. Para 33. While considering the rival submissions, the law on the scope and ambit of 319 is required to be considered. In the recent decision in the case of Sartaj Singh, this very bench has considered in detail the law on the scope and ambit of 319. In the said decision, this court considered the decisions of Hardeep Singh, Mohammad Ispahi, Rajesh, etc. Then, my lord, that decision is quoted extensively here. And after quoting it extensively, right up to page 48, then para 34, the ratio is laid down by the court. At page 48, para 34. It again follows Hardeep. And perhaps it would have to, because it's a two-judge bench and Hardeep is 5, so it would. The ratio of the decisions, para 34, on the scope and ambit of the powers of the court can be summarized as under. At page 49, clause 9. Again, after charge sheet is filed and before the pronouncement of judgment, except though it's the same, Now, my lord, some judgments of different courts, my lord, where similar view is taken, high courts, if your lordship wants, I can just quickly take your lordship through, or I have attached 5 or 6 of them, my lord, where there are all single benches of the high courts, my lord, where 3 or 4 of them are before Hardeep Singh, also take the same view on a plain interpretation of 319. And the others are after Hardeep Singh, and if they are after, then naturally, my lord, they will have no option but to follow Hardeep Singh. So, my lord, my therefore respectful submission is that so far as 319 is concerned, the provision of the section itself is crystal clear, my lord. I have labored yesterday enough on it. I did not again labor on that, my lord. And it is conditional at the cost of, my lord, extreme repetition, my lord. I just 3191, where in the course of any inquiry into or trial of an offense, it appears from the evidence that any person not being an accused has committed offense for which such person could be tried together with the accused. So that's the crucial part, my lord, together with the accused, and therefore the court has the power. Also, my lord, this section appears in that part of the code, which is chapter 24, which deals with general provisions as to inquiries and trials. That's the placing of the section. It is placed in the part of the code which regulates how inquiry and trial is to proceed. So if the trial itself is over, then there is no question of exercising power under 3192. And that I have said, when it is fixed for pronouncement of judgment, and after judgment, the court becomes functus officio. So that is one part. Now, my lord, I need to clarify one more on this thing, lord. And that is, lord, the order by which the trial was separated. Kindly have that order, my lord, dated 28 September 2017. It is at page 537 of volume 2 of the additional document.
Judgment what you read also is that after trial and before pronouncement also it can be done. 362 was after judgment, no review, no change except clerical errors. But now, I mean, just to put the matter in our case, it may not arise because 3110 was the date when it was posted for judgment, judgment was pronounced. Let us say in a case, trial is complete, arguments are heard, the matter is posted for judgment. Because the provision 319, what you say is also is the power of the court to find out whether somebody has been left out deliberately to include that section. While assessing the evidence, the judge finds that somebody else should have been. At that stage, he does not pronounce the judgment. He says for further hearing.
Correct.
At
The
that,
trial revives.
it revives. So at that stage, it can be done.
Correct.
Just to put the matter.
So I was also, because there was a hiatus between posting the matter for judgment and pronouncement of judgment.
Correct.
So we were also discussing yesterday, and I would have said it a little later, that what happens if when the judge is sieving through the judgment and he finds that actually this man is
Correct.
It should be the main person who should be there. Then, my lord, according to me, he would post it for hearing, and then he would pass an order under 319, and thereafter proceed accordingly. Is that kind of a situation has occurred in a judgment, my lord, which is actually a one-pager. It is
Patwalia, just 1 second, 1 second. See, the language employed in 353 is 353.
yes.
The judgment in every trial in any criminal court of original jurisdiction shall be pronounced in the open court by the presiding officer immediately after termination of the trial.
Or at some subsequent.
That's all right. Supposing immediately he pronounces.
Then we are in my situation. Then according to me, he cannot do it.
No, no, he has an option to immediately pronounce. No, no,
Correct.
what I mean is, my brother asked a question. No, does it make any difference at all? Because if he immediately pronounces or he pronounces on a future date. So once the hearing is complete and once it is posted for judgment, the only thing he can do is he has to pass a judgment this way or that way, on the same day or on a future date after reserving the matter. Just to throw some light on this.
So on that note, what my submission is, if he passes the judgment, the crucial point is when he passes the judgment, because trial is over when he fixes it for judgment. Then we are in a situation where trial is over, but there is no judgment. So the court really is not functus officio. The court is still in session of the sessions case. This case will show. It's very interesting. But first, let me complete this. Then I'll tell your lordship how this case will show this problem. So he is still in session of the trial. So at that point of time, he has two options if he has not pronounced judgment on the same day when he has closed the trial. He can then repost the trial for hearing. And if he reposts the trial for hearing, he can pass an order under 319. Or he can pass a judgment. But according, in my respectful submission, the moment he passes a judgment, he in any case becomes functus officio. Then he cannot pass 319. Why? It has happened in this case, and that's why I'm showing these orders. What the learned judge does in this case, on 28 September 2017, he passes an order separating the 319 application and saying, I will continue with the trial. This I am separating. Now, when he separates it, in what trial is that application? So he numbers it as a miscellaneous application in no trial. So he says it will be numbered as a miscellaneous application. He has no power to entertain such a miscellaneous application. I'm going to read those orders just now. When the trial is over, he passes the judgment in trial number so-and-so of 2015. But on that, then when he sits to decide the application, that trial is already over. So the order in the application is passed in a miscellaneous application number so-and-so. It is the procedure and the existence of the application is unknown to law. And this case is a very good example of that situation. Now, therefore, that's what I'm going to show to your lordships just now. Now, kindly have this order at page 537, where he separates the application from the trial, and then what happens as a consequence of that.
It's in which volume?
It's in volume 3, my lord, volume 2 of those additional documents. It's a thickish volume, yes.